oral arguments in a day or two on the web if you'd like to do that. But because we are live streaming on the web, I would like to ask everyone who's in the courtroom to please turn whatever electronic devices you have with you either off or onto airplane mode, because if you receive a text or email during the course of the oral argument, it can interfere with our proceedings, if not with the recording equipment. Counsel should have received copies of our oral argument instructions, and if there are any questions about those instructions, now is the time to raise them. Hearing none, I would ask counsel to go ahead and proceed with your argument.
May it please the court, my honorable opponents. My name is Blaine Myrie. I'm counsel for Harlow. Foreclosure of a senior deed of trust extinguishes junior liens and encumbrances, including easements. The trial court reversibly erred in holding that the foreclosure of Harlow's senior deed of trust did not extinguish the new ditch route. The trial court also reversibly erred in granting summary judgment for FRICO on the old ditch route deeds. Those deeds are ambiguous, and under this court's case in Allen versus Nickerson, as well as the Supreme Court's case of Lazy Dog Ranch, it was improper for the court to grant summary judgment on those ambiguous.
Can you hold on just a moment, Mr. Myrie? I'm
Yes.
sorry. Bailiff, can you start the clock, please? Yes. Thank you.
Extra time. So I'll address the two issues in order. First, the foreclosure issue regarding the new ditch route, and then the summary judgment on the old ditch route. On the foreclosure of the new ditch route easement, there is no Colorado case law that holds that a ditch easement cannot be extinguished through foreclosure of a senior deed of trust. Here, the deed of trust was recorded, executed in 2004 as part of the transfer of the property from Harlow to Aberdeen. And the subject property was subject to that deed of trust recorded as of 2004. In 2006 and into 2007, FRICO and Aberdeen cooperated to create this new ditch route easement. They created it through, initially it was supposed to be a proposed agreement to relocate the easement. That never was an executed agreement, but ultimately, with Aberdeen's financing and assistance, the new ditch route was constructed in 2006 and into 2007, and in 2007, FRICO began running water through the new ditch route easement and allowed the old ditch route to dry up.
Counsel, what are we to make of the fact that that agreement never materialized? I mean, what if legal effect, if any, does it have?
Well, Your Honor, I would say two things. Number one, there's no a written agreement we can look to define exactly what the exchange was supposed to be. On the other hand, I think we can imply a contract existed because Aberdeen assisted in getting the new ditch route fully constructed. And FRICO, through its conduct, allowed the old ditch route to dry up and ran its water through the new ditch route. So I would argue that there is a contract, although it's through the conduct of the parties being Aberdeen and FRICO.
And how do you overcome, I guess, restrictions on oral contracts involving land?
Fully performed. If it's fully performed, it takes it out of the statute of frauds. And that's indeed what happened. But even if there were a written agreement to do this and to relocate the ditch from the old ditch to this newly created new ditch route, the new ditch route was at all times subject to the deed of trust. The deed of trust is senior, recorded in 2004 before this occurred. Therefore, it was created and subject at all times to the deed of trust, meaning that it was subject to being extinguished by foreclosure.
Mr. Myrie, what about the language from the Colorado Supreme Court in the Rogers case that held that transfers or creations of easements are irrevocable?
Well, there's two issues there. Number one is the creation of the easement. The creation of the easement can be irrevocable, but that's a separate issue from the creation of the easement. So, in other words, the party that allows the easement to be created can't revoke its consent to the creation of that easement. But that's a separate issue from what is the effect that a senior deed of trust has. The easement was created at a time when the property was all subject to this deed of trust. And therefore, the creation of that easement, the creation of the easement itself may be irrevocable, but the easement can still be extinguished through the foreclosure, through the deed of trust.
If what you're saying is true, doesn't that mean that the word irrevocable has no meaning?
No. No, the irrevocable act is you can't take back your consent to the easement. Now, it's important to note that it was Aberdeen that consented to the building of the easement. Aberdeen owned the property at the time. Harlow's role was simply as a secured party whose security was the property that is now landlocked by the two ditches.
Right, but Harlow was the successor in interest to Aberdeen, isn't that correct?
Through the foreclosure, yes, and the foreclosure under the Burlington case extinguishes the deed of trust. And I want to talk about the Burlington case because the trial court, frankly, got the case wrong. That case talks both about abandonment and extinction. And I want to look at what the trial court actually said. And this is at page 2510, 2511 of the record. The court said, the Burlington court ruled that because of the abandonment, the ditch was extinguished at the time the foreclosure occurred. If you read closely the Burlington opinion, that's not at all what happened. The deed of trust that was foreclosed on in Burlington was foreclosed on in 1875. And if you read the Burlington decision, what the court said about that is there was the deed of trust that was executed in 1875 or earlier, we don't know exactly when. After that deed of trust was executed and recorded, a deed granting a ditch right-of-way was executed. So you had, just like this situation, you had the deed of trust recorded, and then you had subsequently, in this case, a deeded ditch easement. In 1875, that deed of trust was foreclosed, and the effect of that was to terminate the junior ditch easement. The Supreme Court said, and I quote, "The trust deed attached prior to the granting of the right-of-way to Sigler and Company," that was the ditch company, "and through the subsequent foreclosure of the trust deed, whatever rights that company had were terminated, and the title passed to Strong," who was a subsequent purchaser, "freed of any rights which may have been conveyed to the Sigler ditch." So the Supreme Court is saying the foreclosure extinguished that easement. Now,
Assuming that's true, didn't later Supreme Court jurisprudence change that rule?
there's not a case that I'm aware of. I'm not aware of a case that has said that a foreclosure cannot extinguish a deed of trust. I'm sorry, a deed of easement.
Mr. Myrie, after the Supreme Court stated what you just quoted from the Burlington case, didn't it say, notwithstanding what we just said, the real issue here was abandonment?
Well, I don't think that's what they said. They say notwithstanding that that occurred, the ditch was still running at the time of Strong's conveyance, which was an 1881 deed. So the ditch apparently was continuing to run water. And then there was, in the deeds, and this involved a situation of deed interpretation, there was what I would call a reverter clause, although that may be inaccurate, that if the ditch was abandoned, the property would go back to the owners. So Burlington, I think, supports both an abandonment theory and a foreclosure theory. But even more importantly is the position in Burlington that the foreclosure of the deed of trust extinguishes the easement is consistent with the restatement third of property, section 7.9, which we did cite in our briefs. Section 7.91 of the restatement third says, a servitude is not extinguished by foreclosure of a lien against the estate burdened by the servitude unless the lien has priority over the servitude. And that's the case here, a 2004 deed of trust and a 2007 easement. The comment A to the restatement fully supports extinction of the easement. Foreclosure of a lien that has priority in time or recording extinguishes the burden of the servitude, and the purchaser at the foreclosure sale takes free of the servitude. That is this case. When Harlow foreclosed in 2014, the new ditch route was extinguished, and Harlow took that property free of that easement. So it was reversible error for the trial court to hold that the foreclosure did not extinguish the new ditch route. And it's important because of the conclusion the court made regarding the old ditch route. With FRICO owning, according to the trial court, the old ditch route in fee simple, and with the new ditch route being established, there's now a significant portion of Harlow's property that is landlocked. And the access to that property, which is considered for development, is landlocked by this decision. As the evidence is in the record, of Aberdeen's president said, it was always an agreement to swap the ditches. It wasn't an agreement for FRICO to have its cake and eat it too.
Mr. Myrie?
Yes.
One of the briefs says that this case really involves a dispute between property law and water law. And I haven't heard you say anything about the applicability of water law. Could you comment on that?
Well, I don't agree with that. I don't agree that this is a water law case. I think this is, number one, it wouldn't be in this court if it were. But number two, it is a property law issue. Yes, water is important in Colorado. Yes, ditch easements are important in Colorado. So are utility easements, road easements. You're talking about access for vital services. A ditch easement stands in no different standing in Colorado than do other important easements when it comes to foreclosure. And if this court were to hold that a foreclosure cannot extinguish the ditch easement, I think it would fundamentally upset property law in Colorado, and it would be completely at odds with what the restatement says regarding property. And to the extent that were necessary, that would be something for the legislature to address, not the court. I want to briefly address in a few minutes the old ditch route. Here, this is just simply a case of the trial court entering a decision on summary judgment when summary judgment is inappropriate, given that the deeds are ambiguous. The court relied on the Sun Production case, a 1986 case out of this court that had similar deeds, and in which this court, on summary judgment, resolved the deed ambiguities in favor of FRICO and in favor of fee simple ownership. That case really doesn't stand up after Lazy Dog and Allen versus Nickerson. Lazy Dog says that where deeds are ambiguous, it becomes a question of fact as to what the party's intent are. A question of fact where there is two reasonable interpretations of a deed means that it has to be a trial on the merits in order to decide the issue. This court in Allen versus Nickerson said if a deed is ambiguous regarding the party's intent, summary judgment is not appropriate. So on the old ditch route, that needs to be reversed and remanded for a trial on the merits where the parties can present their evidence of what the intent of the grantors and grantees were in those original deeds. And unless there are further questions, I'll reserve the balance of my time for rebuttal.
Thank you. You have a little 2.5 minutes, essentially.
Thanks.
Good morning, Your Honors. Matthew Rourke, Fairfield and Woods, 38434. May it please this court and honorable opponents. I think Judge Tallman was on point when we start talking about the issue of ditch rights versus general real estate law, and that is an issue that this court's going to need to take a look at. I don't think there's any doubt, based upon the cases that we've cited in our brief, that there is a difference between the law concerning irrigation ditches, the absolute rights that go with that, versus your typical real estate case, which when you deal with foreclosures. In the cases that we've cited, Hitty, it's effectively acquiring a right by grant with the new ditch route. Once the water flows, that's in our view the end of the argument. We now have an absolute right, a title equivalent to one acquired by grant, and that right is absolute against all persons. So when it comes to that new ditch route, there's no basis to establish that a foreclosure would somehow eliminate a ditch company's right to run water through that land. And what I would ask this court to look at on that issue is obviously from a public policy standpoint, you could imagine the negative impacts that such a ruling would have on thousands of miles of ditch that run water in our state that could then be called into question when the foreclosure happens on that property. It is just not what Colorado law provides, and it would essentially turn on its head 100 years worth of ditch law.
Is it dependent on whether there was notice given of the foreclosure proceeding?
No, not at all. The foreclosure proceedings have really nothing to do with the absolute right to run a ditch. Whether the foreclosure went in, we were provided notice or not, the fact of the matter is once that ditch is put in place and water is flowing and being delivered to the customers in Colorado, the fact that notice may or may not have been given is largely relevant. But in this case, we weren't given notice, and if the omitted party issue, which they contend was not raised at the trial court level, but was, as we pointed out in our briefs, exhaustively pled and argued and considered by the trial court, that situation, we don't even get to the issue of notice on the foreclosure because of the long-standing law that we have an absolute right to run water. You cannot extinguish that right, whether through foreclosure, providing notice, or any other process.
Well, what are we to make of the Supreme Court case that's cited by your learned opponent? Is that still good law on the foreclosure matter?
Well, the Burlington case, Your Honor?
Yes.
Yeah, the Burlington case, in our view, despite the language that was cited, that was an abandonment case. It was not a foreclosure case. And I think when you look at that case and read it in its context, what you'll see is, in that case, the abandonment occurred prior to the foreclosure, and so when the conveyance took place and the foreclosure took place, there was nothing to convey. It's not really a foreclosure case, and I would certainly say, based upon the other case law that we've cited that has not been overturned with respect to absolute rights, that this court needs to come to the conclusion that once that consent is given, once that water is flowing through that ditch with that new ditch route, the ditch owner has an absolute right to maintain that facility, to transport water, and under no circumstances can that right be extinguished through a foreclosure process.
Counsel, can you address your opponent's contention that full performance means that the oral contract can be enforced?
Your Honor, that supposed agreement is, in our view, sort of a red herring. As an initial matter, they never pled breach of contract. They never pled they were a third-party beneficiary. I think when you read between the lines, you'll note that they never did that, because had they done that, they would have come up against not only a statute of limitations argument, a third-party beneficiary argument. They also would have dealt with the fact that there was no dollar amount, no consideration, no completion of the agreement. It's not my client's fault that Aberdeen disappeared in the middle of this project and didn't fulfill their obligations. So as far as that issue, we don't really see it as being germane to this case.
But Mr. Rourke, following up on Judge Fox's question, I think Mr. Myrie's argument is that full performance takes an agreement out of the statute of fraud, so that regardless of whether, as I understand it, what he's saying is regardless of whether there was ever a written agreement, that just the fact that that Aberdeen or that FRICO acquiesced in the, that Harlow or Aberdeen acquiesced in the construction of the new ditch means that the statute of frauds doesn't apply. What is your response to that?
There was no full performance. You'll notice that in the unsigned draft written agreement, there is a big gap in there for the consideration that was going to be paid to my client for conveyance of its fee simple interest in the old ditch route. That never happened. You'll also note in the agreement that there are various insurance requirements. There are various other steps that need to be taken that were never taken. So there was no full performance in this case. And I'd also reiterate again, this was not an issue that was ever raised as far as a breach of contract claim or third-party beneficiary argument at the trial court level. So I don't think it's something that this court really needs to delve into.
Counsel, your opponent also makes the point that the two ditches essentially landlock part of your opponent's land. But doesn't the landowner still have use of the land regardless of whether the ditches occupy it?
Yeah, the concept that Harlow is landlocked right now, I don't believe is an accurate depiction of what's going on. They currently have access to the land. We've cited in the record 1386, 1030 through 1032, and 1896. They've done concrete removal when there was an EPA or some sort of public agency investigation. They're operating a horse barn. They're leasing the land out for farming. Again, the issue of landlocking is not something that my client created. Even if they were landlocked, there are procedures in place for FRICO to address that. They can come and ask for access. They haven't sued for an easement by necessity. They've never asked for some sort of formal access agreement, and FRICO routinely grants those types of issues. So we're landlocked. Please give us relief here by giving us one or the other of these ditches. It just doesn't ring true at this point. I would like to address the old ditch route and the argument that this has to be remanded back to the trial court because of the finding by the trial court that it was ambiguous. I don't think Lazy Dog and the Allen cases go as far as my opposing counsel suggests with respect to that issue. In this case, we have deeds that are over 100 years old. If you read those cases and the issue of, do you bring in extrinsic evidence to see what the intent of the parties were? In this case, I don't see what are the disputed issues of material fact. All we have is the language that's in the deeds and what's been interpreted in the Sun Production Court, which the trial court followed. There's nothing else out there that's going to help provide any clarity on this issue, and I think the trial court was correct. You presume that it's a fee simple. She went through her honor went through the analysis and followed the Sun Production case and looked at all the language. That is what we have. There's nothing else out there to suggest that there are any real material issues of disputed fact that need to be addressed by this court. And I would also say that I do not believe it's the law in Colorado that if a contract or a fee simple interest, a deed is ambiguous, that it absolutely has to be, go through a trial on the merits and in a sense remanded back to the trial court. I don't think those cases go that far, and in fact, I think when you look at what's before this court as far as the material facts of this case, we have the language, in the documents. And I'd also point out, frankly, that the ambiguity that they're now arguing was never raised at the trial court level. They never argued that it was ambiguous. Both parties argued that it was clear on its face. It was the court that then took that step.
Mr. Rourke, I have a practical question. Judge Anderson held that that FRICO had a fee simple interest in the old ditch. But as I understand it, that old ditch isn't being used for anything at all. Is that correct?
Well, the old ditch right now is fee simple land that belongs to FRICO. Currently, there is no water running through the ditch, but I'm not aware of any requirements that a landowner actually have to make some sort of active use of its fee simple land in order to avoid some sort of risk to its fee simple property rights. So the short answer is there's not much being done out there.
So, and is the old ditch on land that belongs to Harlow, or is it just outside of land that belongs to Harlow?
It is outside of land that belongs to Harlow. In fact, if you look at the Harlow's deed of trust, they expressly exclude that land as far as the old ditch route's concerned. So there's no deed out there that from the Harlow side that suggests that old ditch route is part of their property or meets and bounds. And they never have. In fact, the record will show that when the issue came up with having to remove all the concrete out of the old ditch, they went ahead and told the public agency, that's not our land. That belongs to FRICO. Why should we be cleaning up someone else's land? So, the arguments that they're making now are really inconsistent with the record before the court. If there's nothing else, I think I've exhausted my arguments. I'll be happy to entertain any other questions. Nope. Thank you.
Thank you. I'll try to address these issues. First, on the ambiguity argument, the notion that it wasn't raised was completely refuted in the reply brief. If you look at the record, pages 1585 and 86, that's where Harlow mentions that the deeds are ambiguous. The issue was clearly raised and preserved, and even if it hadn't been, it was an issue the trial court ruled on and therefore can be addressed in a challenge on appeal. Talking about, what do we do with this 100-year-old deeds when you have to figure out what the party's intent were? Well, there's lots of things you can do. There's historical records, there's historical experts, there's other cases that have aerial photographs and things like that. There's all kinds of evidence that can be brought to bear to show what the party's intent was, whatever that may have been. So the notion that the deeds are too old to really have a meaningful trial, I think, is not accurate.
Was any of that kind of evidence offered to the court as, useful to resolve the ambiguity?
No, that's, yeah, I mean, I'm just talking hypothetically, this is the type of evidence you would bring to bear, which is one of the reasons I think is appropriate to allow the case to go forward. I want to talk about the public policy because I think there's competing public policies here. We heard about the sanctity of water in Colorado and the sanctity of water law in Colorado. But there's also sanctity in the security that a deed of trust provides. And this is a $4 million piece of property. It's not just, a corner lot in no man's land. You have the sanctity of the recording statutes. The deed of trust was recorded to put everybody on notice that this property was burdened by this substantial deed of trust. And the certainty and notice that the recording statute and the recording system has is a vital public policy as well. And to hold that the foreclosure of a senior deed of trust does not extinguish an easement would, in my view, be a sea change in Colorado law. FRICO talks a lot about their cases, particularly in their brief, that support their position that this is irrevocable. Once a ditch is established, it can't be revoked. But not a single one of their cases addresses this situation where you have a deed of trust that is foreclosed on and that is senior to the easements. That is the Burlington case, and that's why Harlow should prevail. Ask the court to reverse the judgment and remand for further proceedings. Thank you.
Thank you to both counsel for your arguments and your briefing. They will help us to make a decision in this case. Your case will now stand submitted, and a written opinion will issue in due course. So once counsel have cleared the tables, we're ready for council to set up in North Range versus Commerce City. Time to raise them. Hearing none, appellant's counsel, you may proceed when you're ready. No rush.
Thank you, Your Honor, members of the panel, honorable opposing counsel. It is my intent to reserve approximately 5 minutes for rebuttal, and I will attempt to aim my arguments appropriately.
Great, thank you. Counsel, can you give us your name? And
Yes.
Thank you.
Paul Ruffin, appearing on behalf of the North Range Metropolitan District.
Thank you.
For efficiency's sake, I think it would be helpful for all involved to frame this case and begin with what this case is not about. This case is not about the price to be determined by the district for the subject to ERUs. As the trial court properly held, that's a matter for the future. That was not raised before the trial court. That was not an issue before the trial court. This case is not about whether the district can exercise unfettered discretion in ultimately setting that price. Despite opposition's arguments to the contrary, as they repeatedly say that that's what the district is attempting to do at every step of these proceedings and every step of the record, the district has said that's not what this is about. The district is not attempting to exercise unfettered discretion. It understands that an applicable standard applies, and it will abide by that standard.
Mr. Ruffin, I'm confused. I thought in your reply brief you stated that there was evidence in the record of the cost for selling the ERUs, and your opponent disagreed with that.
It does exist within the record. In fact, there's extensive reference made to it by the opposition. It is there. At the culmination of the trial court directed the district to establish a price for the first time. And even though it had appealed and we were headed here, the district complied with that order out of respect for the trial court and did provide a price. That did result in subsequent motions from the opposition that have been stayed pending this appeal. But at all times during the actual lower court proceedings, there was no price set, and that is not subject of the appeal. But you are correct that it does exist. The district has, in fact, established a price, and any attempts by the developer to state otherwise, which in fact they do, are just frankly misleading the court because that price has been set. This case is also not about contract interpretation. It's stipulated at this point that the document, the core underlying document, is a covenant. It's a declaration, it is a burden, it is an encumbrance against the property. It is not a contract, and contractual interpretation law does not apply. That is one of the fundamental errors by the trial court. Similarly, because there is no contract, this case is not about delegation. There was no delegation because there is no contract to delegate. None of the elements of delegation exist here. And the trial court was in error, first in finding that there was a contract, and second in its strained interpretation to try and pigeonhole delegation as part of that interpretation. This case is about the proper enforcement of a covenant, an encumbrance against the land. That's stipulated at this point. In the answer brief, the developer stipulated this is a covenant, not a contract. Subsequently, the developer tries to gloss over that and say, well, they're one and the same. They should be interpreted the same way. The same standards apply. That's not the case. This court is reviewing a document and should apply those appropriate standards for document review. And there's
Which are the same rules that we apply for contract interpretation, right?
to some extent, they begin with the same standards.
Where do they diverge?
They diverge in the applicable standard to apply. For contracts, as argued by the developer, there is the inherent good faith and fair dealing. That is something that exists in every contract. There's no dispute that that exists. But this is not a contract. The district was not a party to it. It did not negotiate it. It did not sign it. It is simply mentioned within the covenant. And Colorado law regarding covenant enforcement has a different standard, arbitrary and capricious. That is the standard to be applied here. The
So,
cases,
Mr. Rufian, I'm mystified by what you just said. I'm not clear at all as to what the difference is between those two standards. Can you tell us your thoughts on that?
sure, the difference is in the language inserted into the covenant by the trial court and now argued by the developer, where the new language doesn't exist anywhere else, attempting to become a new standard, fair market or commercially reasonable. The trial court applied that as though it was a standard. The developer argues that as though it was a standard, but it is not.
But
That is not the
can you
standard.
give us an example of some kind of situation where there would be a price for the sale of the ERUs that would not be something that's commercially reasonable, but yet would not also be arbitrary and capricious?
I think perhaps the example here before you today would fit within that category. We are not here, that is not the issue. We can always start with the absurd. The district can't charge $1 billion for this. That would be both not good faith and also arbitrary and capricious.
Right, so if that's the situation, then there's no difference between the two standards.
I believe there is, and I believe there is under the developer's arguments, where they are attempting to say commercially reasonable is market value as they define market value to be. Here, the district holds ERUs under the underlying assignments, a fact that cannot be ignored. The underlying purpose of what led to this covenant is important, and the district has a contractual obligation separate from the delegation that these ERUs can only be used for the development of this property. And it had to expend money, it had to finance that, its tax-paying constituents are paying for that, and its policy and its intent to recover costs is the appropriate standard, both under the BBC case, the Evergreen Highlands case, and most particularly under the two Krupp cases. Cost recovery is a valid standard. It meets the burden of good faith. It meets the burden of reasonableness. If we go into Nolan-Dolan type arguments, it meets the burden of rational basis. It may not, and I emphasize may because we don't know, but it may not meet market value. You're going to hear from the developer, they could go on the open market and obtain ERUs for less. That may be market value. It may not, because this is a very unique, very specific market within which we're dealing. These specific ERUs held by this district under these underlying agreements. I would contend that is the market. And under that analysis, I think the two standards would dovetail, that good faith would then also marry with arbitrary and capricious. But the counterargument that is being made and will be made to you today is contrary to that.
Is there any legal principle that would require the district to charge fair market value for the ERUs?
I don't believe there is, not in this particular case, because of the unique nature of this asset, if we want to consider it an asset. There is no market.
Is it unique?
It is unique because of the underlying agreements, the assignments that are
But
part of the
aren't
record.
ERUs available in other contexts outside this case? the facts in this case.
They are, yes. ERUs can be purchased. In fact, they are purchased all the time to support development. You will hear from the developer that ERUs exist and they could buy them elsewhere for less. That's part of their argument. But these particular ERUs are unique because they are bound contractually. Not because the district wanted to, but because Commerce City, the applicable sanitation district, and another metropolitan district all bound the district to hold these specific ERUs only for this purpose. The district cannot sell these ERUs on the open market. They are legally forbidden to do so. So the market for these particular ERUs is just extraordinarily narrow. And therefore, under that particular analysis, if that is the market and the district has its discretion as authorized under the declaration to set the price for these ERUs, then market value and arbitrary and capricious, again, they will dovetail because that will be reasonable. And I contend, and the district contends, that that's what the Krupp cases in fact stand for. Cost recovery is a reasonable factor for the district to determine and setting that market. We don't know what the word market means in the trial court's order, except for the fact that Judge Anderson did tie it to a contractual interpretation, not an interpretation of a government. We do know what the developer argues, and the developer argues is that they get to set the market price because of what they could buy elsewhere in more of a free trade market system.
Mr. Rufan, one thing that also puzzles me is your assertion that the ERUs here have to be used for the property owned by leased housing associates. Given Judge Anderson's ruling, what happens to the other 83 ERUs?
If not taken by this developer for this property, they will be rendered useless. It will be a valueless asset that the district is forced to have. It's forced to carry. Not with the burden, however, passed on to its constituents. Again, that is part of the rationale of the Krupp cases, is that the general constituency should not bear the burden of private development. Leased housing associates purchase this property knowing of the language of the declaration. That is the difference.
If what you say is true, then why is there language in the declaration that refers to ERUs purchased after, I don't remember the specific date, but after that date?
The honest answer, I don't know. The district was not party to those negotiations. The district does not have any history as to why that was there. If you will note for the record, the timing of the various assignments along with that declaration is very, very tight, very, very narrow. It is possible that that language and the timing of the recording were simply an error and that it was in fact intended to capture the rest of those. I do not know that. We don't have a record of that, but that is a possibility. But the reality is, by the plain language of the documents, the assignments absolutely restrict the district from all 89 ERUs. It can only use them for that purpose. The declaration has language that conflicts with that. But the undisputed language of the declaration is that the developer must acquire district ERUs first, and that the district has absolute discretion, not unfettered. It is bound by a statute, but it has the discretion to set the price. That's the four corners of the document. The district does not dispute that that should be enforced, but it needs to be enforced consistent with the underlying purposes, and it needs to be enforced consistent with Colorado law, and that's the Krupp cases, that the district can, in fact, consider the burden of private development and can, in fact, establish cost recovery as a reasonable, rational basis. Therefore, under those applicable standards, the price set by the district should be upheld. I exceeded my 5 minutes, but if the court permits, I would like to reserve the remaining time for rebuttal.
You may. You have a little over 2 minutes, 2.5 minutes.
Thank you.
Good morning. May it please the court, counsel, colleagues. My name is David Davenport. I'm an attorney with the law firm of Winthrop & Weinstein in Minneapolis, Minnesota, and I am appearing here today pro hoc vice, so thank you for that opportunity. Before I get into my prepared remarks, I'll try to address a couple of the questions that I heard from your honors as it relates to the argument of my colleague. if you take a step back and wonder what will happen with the 83 ERUs if this declaration is enforced as drafted and as interpreted by the district court, you can refer specifically to a letter written by the North Range Village Metro District on October 6, 2017. It's in the record at CF, page 770 is the first page. And this is their effort after the trial court made its determination and instructed them to set a commercially reasonable price consistent with their duty of good faith and fair dealing for the sale of 6 ERUs. They contend they have done that. Respectfully, I disagree with that. Specifically, what they say in paragraph 3 of that letter is, if you decide to accept less than the 89 ERUs assigned to your property, the district will negotiate with Commerce City, South Adams Water and Sanitation District, and the PV Water and Sanitation Metropolitan District to see if they will allow the district to sell the remaining unused restricted ERUs to another third party. If the district is successful in obtaining those authorizations needed, et cetera, then they will try to sell them out on the open market and credit my client for its purchase price. So they really effectively have not set a price for 6. They said, we'll sell you 6 at the price for 89, and then we'll go out and get the releases that we need to lift these 83 remaining ones so we can go out on the market and sell them, and we'll credit you back. So we don't know what the price is, but what we do know is the 83 ERUs will not be rendered meaningless, and they will not be rendered useless. And to drive that point home, if you examine the assignments that give rise to these ERUs, one of them being in the record at CF, page 399, there's a provision in each of the assignments that discusses what will happen. They have the ability to get together as a group, PV District Enterprise, Commerce City, South Adams, and the Water District, to amend the restrictions as it relates to the property descriptions. So years ago, they acquired these 89 ERUs, and these intergovernmental agreements through these governmental agencies said, we're going to set them aside and require that they go with the subject property. The declarant at that time said, I will take 6, and any subsequently acquired ERUs after the declaration is recorded. And so what we have going on here really is a serious effort on behalf of the district to take those intergovernmental agreements and effectively violate the sanctity of the property rights of the declarant whose shoes my client stepped into. The declarant said, I'll take 6, and I'll be responsible for 6. They have these intergovernmental agreements that have essentially locked up the district. They can go change those agreements, but you can't just put it all off on my client and say, these intergovernmental agreements say all 89 are for this property, so you have to buy them.
Well, what can't be changed is the declaration.
That's right.
So here's my concern about this case. The district court, and following the lead from your client, read a duty of good faith and fair dealing into the covenant. I've never seen that in a property case before. This is the first time it's ever been raised as far as I know. Why does a contractual duty arise from a covenant that's imposed upon a piece of property?
Because you interpret.
Who's the other party in the contract?
They-
There isn't anyone, right? It's just imposed on the property.
I'll try to take, there's a series of questions in there.
Okay.
I'll try to take them all. First of all, I think we start with the premise that always Colorado courts have consistently, like other courts throughout the country, said we will interpret declarations like covenants, because that's what they are.
Those are the rules of interpretation that we use, right?
That's right. And then covenants get interpreted pursuant to well-established contract principles. In every contract, there is an implied duty of good faith and fair dealing.
Okay, but
So-
those are two different concepts.
But if you're going to apply contract principles to a covenant or a declaration, you
That
should
doesn't convert the covenant into a contract, does it?
It doesn't convert it into a contract, but you're treating it like a contract. And here comes the third-party beneficiary piece, which is another contract principle. They are the third-party beneficiary of certain rights and benefits in that declaration. The right to sell 6 to my client and the right to set a price. And so when they step forward and say, I want to enforce those rights as a third-party beneficiary, then they receive the burdens and they receive the obligations that go along with that, which is this well-set-up principle of a duty of good faith and fair dealing. Otherwise, you're giving them this unfettered discretion to say, you know what, I can charge whatever I
Most
want.
covenants are interpreted to give an unfettered discretion.
I believe we've cited some case law, Your Honor, at least from other jurisdictions where the duty of good faith and fair dealing has been interpreted to apply to the interpretation of covenants.
But it's not entirely unfettered. I mean, we have a governmental entity here, and they're always subject to review under an arbitrary and capricious review standard.
Well, but they'd never raised this 106 argument at the district court level when we were going through this, so that isn't preserved for appeal, and they're not exercising any
Why can't we
judicial,
consider it?
because that was waived at the lower court because they didn't raise it with the lower court.
Mr. Davenport, let me ask you the same question I asked Mr. Ruffian. What is the difference between the two standards that you're arguing that applies?
I believe they're essentially the same. He's using different words to make it appear as if it's a heightened standard, but it's a standard as defined by the trial court as something that is commercially reasonable. She cites the ADT Security Services case that talks about, you need to act reasonably. You can't act outside the accepted commercial practice to deprive my client of the benefit of being able to purchase 6. So you have this standard, right, that I think they're trying to shoehorn in through Rule 106, where they want to somehow make it appear as if they're doing some sort of judicial or quasi-judicial function. They are not. That's not happening here. There are no standards, there are no rules, there are no requirements, there is nothing that you would see that involves the determination of rights, duties, or obligations that apply any pre-existing legal standards. So as we know from the Copley decision, that's what is required for this 106 analysis and this heightened burden that they appear to be arguing for.
So if there is no price that's been determined yet for the ERUs, is this issue being raised prematurely?
In terms of what the price is?
In terms of what the legal standard is, if you just said a few minutes ago, you think essentially they're the same. How do we know? I mean, if the trial court said that the 6 ERUs were, just to pick a number, were worth $100,000, then there could be a discussion of the legal question of whether that is in fact the same under both standards, or there is in fact a difference between them. But we don't know since there's no specific price.
I see your point, Your Honor, and on that particular piece, I generally tend to agree, because what the trial court did was she disposed of their claims, and she did so on a motion for summary judgment relative to our claims, and she said, go set a price for 6 and do so within 21 days. I contend that they did not do so, and so we attempted to go back into the trial court to get them to set the price for 6. They contend they do. We can just respectfully disagree about that. And we tried to get back into the trial court on that narrow issue of what's the price? Did they adhere to a good faith and fair dealing standard when they set that price as she required them to do so? Did they apply commercially reasonable standards? They filed a motion, got that stayed, and it's just sitting there at the trial court. We'll deal with the price issue later. So they haven't set a price, and so when counsel concluded his remarks and said, affirm the price or something in that regard, I don't know how he can say that, because he started his argument off by saying, this isn't a case about the price. So really what this is, Your Honor, as I see it, is the threshold issue is, can you and should you affirm the district court for applying a duty of good faith and fair dealing in the context of the interpretation of this declaration? The court did so based on sound legal principles. She did so based on the fact that you interpret declarations like contracts, which are like covenants, which are treated like contracts. And the moment that the third-party beneficiary of the rights in the declaration stands up and says, I'll take those rights and I'll seek to enforce them, they now receive the burdens. They can't have one without the other. The case law that we've cited in that regard talks about you can't pick and choose. You have to have it all. And of course, that's just fair and reasonable.
Well, why should we conclude that it's not good faith for the district to just try to recoup the cost of the ERUs to themselves?
Well,
Why is that not good faith?
Well, as it relates to the issue of setting the price, I'm not sure we're there yet on that issue. I know he's arguing about that in some context, but We haven't gone to the district court to determine whether or not setting the price based on that argument, this cost-saving argument, is consistent with the duty of good faith and fair dealing. That issue has not been addressed by the lower court. But as it relates to this cost-saving argument, when this issue first arose prior to the litigation, my client went to the district and said, we're required to buy 6. We want to be a good neighbor here. We know you have 89. We'll buy all 89. And they offered him $703,000 for all 89, despite not having the contractual obligation to do so. The reason they picked that number is that's what was reflected on the books and records of the district as their costs. That's what they indicated was the cost structure. This is what it is to us. And then all of a sudden, it's $1 million+. Initially, in a letter from counsel, and it's in the record, they said, well, these are appreciating assets, and we have to protect our investment. And then they pivoted when we got to the district court and said, well, we've got all these costs associated with the bonds that were used to finance them, so now there's another $300,000 in interests and some other costs, and then it matched up to that $1,039,000 number. So as it relates to that question, Your Honor, I hope I've answered it. And I think really just in closing, unless the court had any additional questions for me, I think it's important to note that the district is correct when they say they have a fiduciary duty to their constituents. My client is one of those constituents. And what they are failing to do and failing to recognize is they have the right and the ability to go out with the other governmental entities and change the limiting restrictions as it relates to the remaining 83 ERUs, and they can go out into this market and sell them and
Is
make.
there anything in the record about that, counsel?
It is in CF 399, which talks about a written agreement that they can all consent to change the restrictions. But most importantly, it's in their letter that they wrote to us after the district court made its decision on October 6, 2017 at CF page 770. They tell us specifically, if you want to buy less than 89, that's fine. Buy 6. Still going to cost you the same price as 89. We'll then go get the restrictions changed. We'll try to do that. If we can, then we'll sell them and we'll credit you back that price. That's not how it works. We don't assume that risk. The last remark, Your Honors, is when we're thinking about these issues, and as the court deliberates over them, I would encourage the court to take a look at the K-9 shrink case. It's a Colorado Court of Appeals decision from 2011.
Yes, I remember it well.
I thought you might. So it speaks in there that language of a covenant, if it's unclear, a court will resort to rules of interpretation, and a court will resolve all doubt against restriction and in favor of the free and unrestricted use of property. So if you have any doubt about whether or not you should determine to affirm the district court for applying a duty of good faith and fair dealing principle to this declaration, which is a covenant, I would encourage you to think about the principle articulated in that case. Resolve that doubt. Make sure to apply that duty of good faith and fair dealing to the restrictions so that you have a decision that is consistent with something that is against restriction and in favor of the free and unrestricted use of my client's property. Unless you have anything else, I think I'm done.
Thank you very much,
Thank you.
counsel. Rebuttal?
Thank you. Addressing first, and for absolute clarity, this is not a Rule 106 proceeding in the lower court, and the district does not contend that it is a Rule 106 proceeding. The Krupp cases involved, at least in part, a 106 proceeding, and that is how and why 106 appears in the briefing. It happens that the 106 standard, arbitrary and capricious, is the same standard that is applied for the interpretation of these covenants and the district's behavior under the covenants. The BBC case and the Evergreen Highlands case make it clear that the interpretation of covenants is bound by an arbitrary capricious standard, the same standard as 106. But But if we ever find ourselves in a 106 proceeding, it will be in the future, as the trial court noted, if there is ever a challenge against the district's judicial or quasi-judicial actions.
Do you have concerns if this court were to adopt a duty of good faith and fair dealing jurisprudence as your learned opponent is advocating? And for application to covenants, property covenants?
I do, because I do believe the phrase fair dealing as part of that, as interpreted by this trial court based on the arguments of the developer, invoke terms that are not part of the declaration and are not part of the standard under Colorado law. That being market value or commercially reasonable, which are inserted terms into the declaration beyond the four corners, and we don't know what those mean. In answering some of those questions, they may in fact dovetail. If the market is, as the district defines it to be, then there's no problem. It is acting within the market and commercial reasonableness, and fair dealing in that regard would not present a problem for the district. But I don't think we know what those terms mean. They are not defined by the trial court, and so I think it is more appropriate, more instructive for both parties to look at what Colorado law says, and that rather than fair dealing, we look to as whether the district was acting arbitrarily or capriciously, or did they have reason and rationale for what they did. And the Krupp cases, the most on point of any of the cases. This is not an HOA matter. That's what most covenant cases involve. This is the district acting as a governmental entity, exercising its statutory authority and protecting all of its constituents. Yes, housing associates is one of those constituents, but they argue that they should not assume the risk. The district cannot assume the risk of presuming that it will be granted future authority by Commerce City. It
Thank you,
cannot do that.
Thank you,
Thank you.
counsel. Your time has expired. Thank you to both counsel for your arguments and briefing. We appreciate them very much, and they will assist us in deciding the matter. Your case will now stand submitted, and a written opinion will issue in due course. When you've completed clearing the tables, counsel for our next case may set up. Thank you. And our next case will be Marriage of Shapiro. Please turn off any electronic device that you have that might receive a text or an email during the course of our arguments so that we won't be interrupted and our electronic recording system will not be disrupted. Our arguments this morning are being live streamed on the web, and they are being recorded so that you can review them after the fact. And because they're being live streamed and recorded, council may want to take that into consideration in any discussion of sensitive topics that you might have this morning. If there are questions about the oral argument instructions that you've received, now is the time to raise them. And hearing none, counsel for the appellant may proceed.
Good morning, Your Honor, and good morning, panel. Good morning, opposing counsel. My name is Anselm Efe. My registration number is 38357. I represent Mr. Shapiro in this matter, and I will be referring to him throughout as husband, and I will refer to the respondent, Ms. Shapiro, as wife, if necessary. Your Honor, this case is about property. It's basically a case about property. But in the course of this trial, a lot of things took a different turn. And one of the things that I like to address based on my brief is the fact that the case took a different turn based on the prejudice of the retired judge that was appointed in this case. In my brief, I gave a standard of what it was, and I also would like to make a little reference to what I thought was the action that I could refer to as prejudice. It's uncomfortable to discuss the prejudice of a judge in a case, but in a matter where the only issue that was involved in this case was property, I believe that the husband believes that the prejudice of the judge was instrumental to the way the case turned out.
Counsel, to the extent that you are suggesting that the judge had some prejudice, did you seek recusal of the judge and appointment of a new?
Yes, Your Honor. I filed a motion for recusal of the appointed judge, and we gave reasons for that. In that case, we gave the reasons basically based on something she had done. She found husband for contempt. In this case, even after he had purged contempt, sentenced him to 3 days in county jail. The judge in that case also mentioned that she wasn't going to listen to any issue regarding property whatsoever. In the middle of the case, she also sent to counsel on both sides an article about dementia, saying that we should take a look at that. She also, in sentencing husband to jail time for 3 days, she also warned husband that if he was to be found in contempt again, he was going to be multiples of 10. I think that cast a pall on the case. I filed a motion for recusal before the judge. She considered the motion and denied the motion. And thereafter, I also filed a motion for prohibition to the Supreme Court, who also denied that motion as well. And apart from what she had said in terms of talking about how he was going to be multiples of 10, also in the course of this matter, she took positions that were contrary to law. And because when we talk about bias is not perceptible. Bias is based on the conduct of the judge. What were the things she did that amounted to bias? She decided at the beginning of this case to turn over all the property in possession of the parties for wife, and created a joint marital account where wife will pay all the bills, including fees of opposing counsel. And she also made orders. Some of the orders she made, including when she made an order based on CLCP 70, a post-judgment rule to put all the properties in the name of wife. I felt that was improper. And also, she also will rule on a motion filed by wife before there was any opportunity to respond. There were 2 occasions that come in mind. On one occasion, she ruled the very next day, not giving husband an opportunity to respond. And on another occasion, she ruled almost simultaneously as the motion was being filed, which was a cause for concern.
Mr. Efe?
Yes.
I know that you filed an affidavit to recuse the trial court judge, setting forth specific reasons why you believe that she was biased, but I don't recall that you addressed those specific factors in your brief on appeal.
I did not address those specific factors. What I did was incorporate that into my brief. And I also incorporated the motion that was filed for prohibition in my brief as well.
So isn't there a case law that says that you're not supposed to do that?
That's correct, Your Honor. However, Your Honor, I do believe that her conduct, as far as justice was concerned, cast a pall over this case. In summing up issues, she decided to have a Sorensen hearing. And as far as I know, this Sorensen hearing, so-called, is based on one decision of the Court of Appeal, and I can't find any authority that follows it or refers to it in any particular way. In that situation, in the Sorensen case itself, it was a party that requested that a guardian should be appointed for her. It wasn't the judge. In this case, the judge on her own accord called for a sentencing hearing. And when she did this, what she did was stop the case so that the husband could be evaluated for a sentencing hearing. Judge also appointed an expert of our own to look at the husband. And when she did this after, even though previously the respondent's former attorney had him evaluated by Dr. Martinez, who had said to the court and sent a report to the court that based on the factors enunciated in sentencing, that there was no issue with him being able to understand the proceedings. The judge ignored that, and at that same time, on that same occasion, the judge decided to stop the trial dates and to extend the trial dates until the evaluation was over. And now, when she appointed the evaluator, one of the things she did was, first of all, she didn't have the authority to do that. I don't think sentencing does not give a judge the rule or the jurisdiction to go out and appoint someone for a sentencing hearing, because when he appointed an expert, that expert will be acting in our own cause. That was the first thing. The second thing was when during the course of the trial, the factors that were necessary for the evaluation, the expert witness there, Mr. Spiegel, was not able to understand what the issues of the trial was. And my question to him was, how was he able to evaluate him properly under the four sentencing factors if he did not know what the actual issue in the case was? He came to that conclusion. And after the hearing was done, the judge, I believe, decided that a guardian ad litem should be appointed. And the appointment of the guardian ad litem, she made in her understanding, in her appointment, she stated that the guardian ad litem was to be appointed for all issues, including property, attorney's fees, everything. And she also stated in that appointment that the guardian ad litem should report to the court whatever was in the best interest of the husband. I felt that the husband felt that when that was done, the guardian ad litem did not know what her role was anymore. The guardian ad litem felt she was an officer of the court and did not act in the best interest of husband. The guardian ad litem, the record will show, failed to meet with husband. The guardian ad litem, when appointed, wouldn't sign some documents, and there was delay in it. The guardian ad litem, and this is in one of the transcripts, the guardian ad litem, because he was appointed in this case, in another case in the county court, the judge following this case appointed her as a guardian ad litem. Her appointment was costly. Her appointment delayed the trial. Her appointment caused a wedge between counsel and husband. Her appointment wasn't based on law, and it took away his rights to property, his right to be able to communicate with his counsel, and it made matters very difficult. I think the appointment was harmful. It wasn't harmless error. Also, the other matter I'd like to talk about is the issue of the allocation of property.
Mr. Efe,
Yes.
Before you move on to the next issue, let me just ask you, in what specific request was the appointment of the GAL harmful?
It was harmful because once she was appointed, in first instance, appointing a GAL should be appointed for a party that's incompetent. Mr. Shapiro is not incompetent.
No, I understand your contention in that regard, but let's assume that you're correct on that argument. But even so, what difference does it make, or are you suggesting that it made in the outcome of the case that there was a GAL?
Delayed the trial. It was costly. The appointment was costly. They had to pay expert witnesses who overseed it. We had to prepare for that hearing, and counsel on both sides had to be paid for that. If matter was delayed for 6 months because of that appointment, and most significantly, as far as his rights are concerned, it's not lawful for a judge without due process, which wasn't taking this place, to remove a constitutional right of a particular individual, not allowing him to have access to his counsel. And also, because of the warning that the judge had made initially to counsel about, to the husband about multiples of 10, if he did something wrong at the contempt hearing, he did not want to do anything that would remotely disobey court orders. And one last thing was his appointment in that case was misinterpreted in the other county case, and a GA, or the same GA, was appointed over him in spite of the fact that the case Sorensen doesn't do that extension. I'll address a few more issues before I'm done, Your Honor. An issue of attorney's fees, I believe that there was no basis for it. The judge gave 3 reasons for assessing attorney's fees. He mentioned that the disclosures were not provided, but the transcripts in this case will indicate that in December of 2016, all disclosures had been provided to the other party, and there was no more disclosure to be provided for anybody else. A transcript of Ms. Peterson that was 10/24/2016 indicated that they turned over all the business materials to the other party. And she also said it was because of failed to pay, threatened to file information against. And that was not true because, I mean, nobody filed to threaten. And the record will show that all the motions that were filed were not frivolous, because the motions were filed based on law. And she couldn't be assessing attorney's fees for information that was filed that was based on a legal argument, even if she deemed the information was wrong. And also, she, in assessing attorney's fees, in this case, the fees came from one source, the joint marital fund. So there was no question of assessing fees differently or having fees to be paid back to wife. And furthermore, I believe that just address one more issue that had to do with the property. The only property that was turned over to husband was the property that the value was unknown. And the value of that property eventually was turned up, I think it was about 3.324 million that was given onto husband's account. Every other property's value was known. The value of this property was not known. And it turned out later that the property value was no more than $433,000. And therefore, there was a huge loss in terms of how the property was allocated. I believe the judge talked about dissipation. She misunderstood dissipation. Dissipation, according to Ree Jorgensen, only occurs in contemplation of divorce. When she talked about dissipation in this case, she was talking about activities that occurred before the matter was filed. It wasn't husband that filed, it was wife that filed. That theory is something we stick to closely because dissolution of marriage is without fault. And what the judge did was to go back, have an accountant look at matters that had occurred prior, and then said that was dissipation. It doesn't amount to dissipation by law. One last issue, the issue of continuance. The judge should have granted continuance in this case. There was only one there was no prior continuance in this case except the judge decided to continue the matter on her own accord because of the issue she raised. And when, at the end of the time, when we were getting ready for trial, the accountant that was appointed by the court brought 3 volumes of material to do with finances. And all the request that was asked of the court was 2 weeks for continuance. And the judge refused to do that. I thought that was an abuse of discretion because in the circumstances, knowing that the main issue in this case was finances, the judge should have allowed and accommodated for 2 weeks. She was a retired judge. She didn't have another docket. She wasn't working in the courtroom, and she was being paid for the job, and that's why she was appointed in the first place. She should have accommodated the request for continuance. She failed to do that, and that made matters difficult for husband. Also, I believe that there was an abuse of discretion in that, as far as that was concerned. The judge ought to have disqualified herself when she was asked to, and she should not have continued the case in the manner which she did.
Thank you, counsel.
Thank you, Your Honor.
May it please the court, my name is Jeffrey Villanueva. My registration number is 10,001. I'm here on behalf of the petitioner appellee Patricia Shapiro. Each and every one of the issues raised by Mr. Effe is subject to the abuse of discretion standard, namely whether the trial court's rulings were manifestly arbitrary, unreasonable, unfair, or based on a misunderstanding or misapplication of the law. And each and every argument that has been made by Mr. Effe here is that the court should have decided issues differently based upon conflicting evidence, and that is not how you meet the standard of abuse of discretion. Now, I'd like to dive right into what Mr. Effe contends is the most serious issue here, which is whether Judge Montgomery was prejudiced against Mr. Shapiro. If you could disqualify a judge just because the judge made rulings against you, we'd be disqualifying judges in virtually every single case. Mr. Shapiro was a bellicose, uncooperative, contemptuous, spiteful litigant, and regrettably, Mr. Effe stoked the fire, which is why he was sanctioned with attorney's fees as well. Among other things, Mr. Shapiro just flat out refused to produce any of his credit card statements with this bizarre argument that his account had been compromised. How that prevented him from providing credit card statements is beyond me. And not only did he refuse to produce financial information and drag out the production of just the basic Rule 16.2 disclosures interminably and refused to respond to discovery requests, he actually destroyed documents. In the Nolan Rucker deposition, there's a testimony that Mr. Shapiro, almost immediately after being served with the divorce petition, went into his office, shredded all of his business records, and wiped his computer clean. Among other things, he canceled my client's insurance, all kinds of things. And Judge Montgomery did not rule against Mr. Shapiro in every instance. She gave him multiple extensions of time to file disclosures, to produce discovery. Found it ironic when Mr. Effe said that by December of 2016, Mr. Shapiro had produced all of the financial records. That was almost a year after the case had been filed. And whether he produced all of the financial records is very debatable since he never produced his credit card statements. I would submit to this court that Judge Montgomery bent over backwards, to be fair to Mr. Shapiro, and demonstrated more patience to Mr. Shapiro than he had any right to expect. Having observed his behavior on several occasions, Judge Montgomery was sufficiently concerned about his mental health to ask for an evaluation in the spring of 2016. She allowed Mr. Shapiro's personal therapist, Dr. Martinez, to perform that evaluation, and Dr. Martinez at that time said that he felt Mr. Shapiro was competent, so the matter proceeded despite the trial judge's concerns. Having observed Mr. Shapiro at the contempt hearing, which was a full-day contempt hearing in July of 2016, and having heard my client's testimony that Mr. Shapiro's behavior had suddenly changed. All of a sudden, a man who had been a loving husband, a good father for 35 years, had basically gone off the rails. Judge Montgomery, she saw an article. She saw an article in the New York Times about how when someone's personality suddenly changes, maybe early onset dementia is a possibility. And she sent that to both counsels saying this could be relevant. I would submit to the court that doesn't show bias or prejudice. It shows concern on the trial court for the mental health of an individual. She was trying to encourage the lawyers to understand, or she was trying herself and trying to encourage the lawyers to understand why Mr. Shapiro was behaving so strangely, why this case was dragging on interminably, why they couldn't get disclosures, why they couldn't get anything. And then
Mr. Villanueva, excuse me for interrupting, but in this case, Judge Montgomery, on her own, set a hearing, set up a Sorensen hearing. Is there any authority that permits a judge sua sponte to schedule a Sorensen hearing that you're aware of?
I am not aware of any such authority, Your Honor. I think the Sorensen case can be read for the proposition that the court can do it sua sponte or either party can ask for a Sorensen hearing, but I would concede to the court that there is no authority either way saying who has to file the motion, but I would also submit to the court that it would be ludicrous to say that the only person that can file a request for a Sorensen hearing is one of the attorneys for the parties. So we have this contempt hearing in July of 2016, which is really kind of a watershed moment because there was all kinds of testimony about Mr. Shapiro's changed behaviors, and then we have this $245,000. After this case was filed, Mr. Shapiro secretly went out and accessed a never-before-used line of credit and took $245,000 out, which my client didn't find out about until she got a letter from the bank saying they were about to foreclose on her home. And at the contempt hearing, Mr. Shapiro, among other things, asking about whether it's a proper marital expense for him to take his girlfriend on a trip to France during the middle of the case, could not or would not explain what he had done with this $245,000, other than saying, well, I spent $10,000 on a bike, $20,000 on bike clothes. I took my girlfriend on a trip to France. That's all he could do. He wouldn't produce his credit card statements. And Judge Montgomery, after she found him in punitive contempt, and I know this is an issue Mr. Effie didn't mention in his argument, but it's in the brief, talks about the statement that Judge Montgomery made that when we have this contempt hearing, you better bring your toothbrush. She also warned Mr. Shapiro that he better take some actions to try to purge his contempt to lessen the sentence, and ultimately he only received 3 days in jail for basically stealing $245,000 from the marital estate. So I would submit to the court that it is certainly not inappropriate for a judge, after she has found a party guilty of punitive contempt and that party is going to be sentenced to jail, to be saying, bring your toothbrush, but by the same token, do some things to try to purge the contempt to lessen the sentence, and he did end up getting a very light sentence. Now,
Counsel, to the extent that any of the judge's rulings were based on not having information that should have been provided, isn't there authority to the effect that the trial court can, in fact, impose sanctions for the failure to provide requested or required information?
oh, absolutely, and ultimately, part of the monies that Judge Montgomery found had been dissipated were basically charged to Mr. Shapiro in the permanent orders, because he could never account for them. So yes, the court can draw adverse inferences, which she did by virtue of the credit card statements that Mr. Shapiro refused to produce. Now, if anything, recusing herself would have been the easy out for Judge Montgomery. Mr. Shapiro was an incredibly difficult litigant. And I would submit to the court that it's to her credit that she stayed in this case and continued to make rulings, because Mr. Shapiro and his counsel were doing everything they could to bait him or to bait the judge and to complicate these proceedings and quite frankly to torment my client, because there was evidence in the record that Mr. Shapiro was trying to ruin my client. Let me move on to the issue of the valuation and the division of marital property. Mr. Shapiro or Mr. Effie can continue to complain that the trial court overvalued the assets that were allocated to Mr. Shapiro. And as the case law, such as the marriage of bookout case states, it's within the trial court's discretion to determine the weight to be given expert testimony. And there was clearly competent expert testimony with respect to the value of the so-called Bell Ray businesses to support Judge Montgomery's ruling. She accepted Mr. Hofer's opinions over the opinions of the expert who came from Quist. And you can't reverse Judge Montgomery simply because she did not accept the values that Mr. Shapiro tried to propose to the court. There was conflicting evidence, and Judge Montgomery chose to accept what she considered to be the better evidence. And for the record, because Mr. Effie has alluded to this twice in his briefs, Preston Hofer did consider the $900,000 in debt that was owed by these entities. I could cite to the court the page numbers in the record where it's shown on the financial statements. And Preston Hofer did consider the so-called gainful employment rules, and if you look at his transcript of his testimony, which I did last night, I mean, you do a word search, you'll find that he discussed it in 5 different places in his testimony. So the valuation of the assets is subject to the abuse of discretion standard, and we submit that has not been met. Now, with respect to the division of the marital estate, it's a similar standard of review. It's abuse of discretion, and the trial court has the discretion to divide the marital estate equitably, not necessarily equally, although the trial court did say that she was awarding 51% of the marital estate to Mr. Shapiro. And contrary to the counsel's brief, where they say that all my client did was stay home and take care of the kids while Mr. Shapiro went and made all the money, and that the trial court didn't consider his financial contributions. The trial court did consider his financial contributions. It's mentioned in multiple places in the permanent orders about what Mr. Shapiro had done to build up this business. The court does not have to make specific findings regarding each and every factor under 14-10-113. I mean, that's the Marriage of Powell case. It's not cited in the brief, but it's just basic Hornbook law. We all know that. Now, with respect to the issue of dissipation here, Cheryl Walton was a joint expert appointed by the court to do a quote-unquote sources and uses analysis, which was to look at both parties' spending. And Ms. Walton opined that there was some $426,000 that had been unaccounted for, and that's the number that Judge Montgomery used. And Judge Montgomery also said that despite Ms. Shapiro's counsel's arguments that there was considerably more, I think the words she used was it was close, but she wasn't going to find anything more than the $426,000 that had been contained in Ms. Walton's report. And included with that was the $245,000 that Mr. Shapiro withdrew and could not account it for. But there was all kinds of spending that was going on. I mean, Mr. Shapiro was spending like a drunken sailor during the course of these proceedings. I mean, what he did was shameful. And he could have and probably should have been sanctioned with more, but there was clear evidence that would support a finding of dissipation, which is an extreme finding, but it applied in this case.
Excuse me, counsel, can you address our jurisdiction over this appeal, given that it was decided by not by an active trial judge?
Well, it was decided, and I can't give you the site on the statute, but it's the so-called rent-a-judge statute, and there is a stipulation. I don't know if it's in the record or not, but there was a stipulation at the beginning of the case between Mr. Honeycutt, who was the trial attorney, and Bill King, who was Mr. Shapiro's prior attorney, that Judge Montgomery would be appointed pursuant to that statute. So she had all of the powers of a district court judge. She was just conducting most of the proceedings at the Judicial Arbiter Group. The last issue that I would like to address is the issue of attorney's fees, which I'd also submit is subject to the abuse of discretion standard. And this case was handled in an egregious fashion by Mr. Shapiro and by his attorney. There was over $300,000 spent per side, and although Mr. Effie says, well, it came out of the marital funds, there was an awful lot of marital funds that were spent unnecessarily because of the expansion of the proceedings, the lack of cooperation by Mr. Shapiro. I mean, there were so many status conferences. I want to make a quick comment about the personal property. The court had multiple status conferences, and all Mr. Shapiro wanted to talk about was, I want my sleeping bag. I need my camping equipment out of the house. And so at one point in time, Judge Montgomery did say, we're not going to talk about the personal property anymore until you do your disclosures, because he was being so difficult, and there were 2 or 3 motions for sanctions that were filed. There was all kinds of misbehavior going on the part of Mr. Shapiro. And the trial court, she exercised tremendous patience in getting this case to a final resolution after a year and a half. Ms. Shapiro was tortured during this case, but Mr. Shapiro and his attorney made a calculated effort to make these proceedings as difficult as possible. And I can cite all kinds of references. When we talk about the Sorensen hearing, Judge Montgomery wanted the Sorensen hearing. I think she asked for it in September or August of 2016. Mr. Shapiro refused to cooperate with the evaluation, so it took until February before he finally cooperated with Dr. Spiegel and submitted, and the Sorensen hearing took place. There was so much delay that went on. none of it was attributable to my client. And in terms of continuing the trial date was continued twice. And Mr. Shapiro could have and should have been prepared. And just one last comment, because I know I'm running out of time.
You have run out of time, Counsel, I'm
Oh,
sorry.
okay.
Thank you to
Thank you
both
very much.
counsel. We appreciate the arguments of both counsel and your briefing. They will help us to make our decision in this case. Your case will now stand submitted and a written opinion will issue in due course. And that completes our docket for this morning. The court will stand in recess and the bailiff may so announce.